Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. This time, we are going to speak on the Korea and Korea's perspective on the United Nations Convention on the Law of the Sea, UNCLOS. The third conference on the law of the sea was held amidst rising tensions between maritime powers, advocating to maintain traditional national territorial seas in newly independent states in Asia and Africa, hoping for reform of the international maritime regime in favor of wide high seas. During this conference, South Korea generally agreed with other Asian and African states. In an era where the country was heavily dependent on the United States in politics, economy, and national security, this stance can be assessed as the Korean government's own initiative for the country's rights and interests in the sea. The Korean government's core concern during the conference are listed as follows. The first, unlike the 1958 Geneva Conventions on the Law of the Sea, where the Korean government did not give a definite opinions as to the contention of the scope of the territorial sea, for example, 3 nautical mile, 6 nautical mile, and 12 nautical mile, they were in favor of the 12 nautical mile during the conference. Although the Korean government did not agree with the United States back in 1958 as to the notion of limited coastal state jurisdictional capacity, the government viewed pursuing for 12 nautical mile to be too progressive. In light of the North and South military conflict and armistice in Korean Peninsula, South Korea was in favor of prior notification of innocent passage of foreign warships and government ships operated for non-commercial purpose in the territorial sea. The Korean government, the proposition for prior notification or prior approval, however, was rejected during the 1958 Geneva Conventions. As regard to the right of passage in international strait, the Korean government advocated for innocent passage of warships and government ships operated for non-commercial purposes, but rejected the right of the passage through the airspace and supported the reinforcement of coastal state right to regulate pollution. This was also in light of the passage issues occurring in the Strait of Korea and Jeju Strait. Regarding the limitation of territorial sea, the Korean government was in favor of the median line. Moreover, though between the Korean-Chinese continental shelf and EEZ, a median line would benefit Korea because the nation has already designated joint development zone with Japan. Using the natural prolongation of the land territory, Korea was careful in making its position. Nevertheless, the Korean government agreed that a compulsory dispute resolution measure is necessary for peaceful resolution of conflict and dispute arising out of determining the limitation of the EEZ and continental shelf. As regard to marine science research, MSR, the interests of developed states were toward claiming freedom of research, while developing states sought prior consent of coastal states. Korea took the side of the latter. Let me touch upon recent trends of the attitude of the Asian state towards third-party adjudication, focus on the Korea. In the realm of international law, the attitude of Asian states towards submitting their dispute to international adjudication or litigation has been a subject of the considerable scholarly interest. East Asian countries have not frequently utilized the formal mechanisms of international dispute resolution, despite the potential they hold within the international legal process. East Asian states have demonstrated a varied approach toward engaging in formal international dispute settlement mechanisms. While some states within the region have actively embraced an international adjudication and are willing to resort to international court and tribunals to resolve disputes, others have exhibited a more cautious stance, preparing bilateral negotiations, or non-binding alternate dispute resolution method. Factors such as historical context, geopolitical considerations, national interests, and a perception of efficacy and fairness of international adjudication play pivotal roles in shaping the divergent attitude of East Asian states toward the submission of their dispute to international forums. Understanding the dynamics of East Asian state attitude toward international dispute settlement can shed light on evolving landscape of the international law and contribute to further developments of effective mechanisms for resolving interstate conflicts in the region. Despite the potentially, the international legal process and states in East Asia have not regularly employed the formal mechanisms of international dispute resolution. The several cases from the International Tribunal for the Law of the Sea, including Southern Bluefin Tuna case between the New Zealand and Japan and between Australia and Japan, and the case concerning the land recrimination between Malaysia and Singapore, and two cases related to prompt release, for example, Tomimaru case and Hoshimaru case, the cases between Japan and Russian Federation, and disputes concerning the limitation of maritime boundary between the Bangladesh and Myanmar in the Bay of Bengal shows some changes in terms of attitude of Asian states, which has become more positive in recent years. Some commentators view this trend of the attitude of Asian states towards third-party adjudication. Although this question was not directly related to East Asia's cultural influence on the law of the sea, it can be considered that the different way of domestic interpretation and application of international law in different states would give rise to international disputes. While maybe Japan has more experience in referring the cases to international court and tribunals, the China and Korea are less active in this sense. For instance, the South China Sea arbitration clearly showed the Chinese attitude. It is understood, however, that if the case was convincing, any state would not hesitate to refer the matter to third-party adjudication. It depends on the government decision whether the dispute shall be referred to third-party adjudication or be settled bilaterally. In the case of the ocean and territory, many discussions about territorial dispute in Asia were made and noted that territorial dispute and claims in Asia has been subject to third-party adjudication. The questions require further investigation of whether this trend is a distinct nature of Asian states compared to other parts of the world. In other words, Asian states have been more active in dispute resolution. But in terms of territorial sovereignty and maritime jurisdictional disputes, up until a decade ago, it used to be said that Asian states would only consider binding dispute resolution with respect to certain disputes that were deadlocked. In this regard, there were three cases involving territorial sovereignty issues in Asia, for example, Temporal Priya Bihir, and sovereignty over Pulau Ligitan and Pulau Sipatan, and sovereignty over Petra Branca and Middle Rocks and South Sulawesi, all came from the South Asia. Is very interesting to be noted here. More recently, two cases arose related to Bay of Bengal on maritime boundary delimitation, but this is not from the East Asia, but all from the viewpoints of the strict sense of geographical location. The attitude of Asian states toward international dispute settlement constitutes a crucial aspect of their approach to international law and law of the sea, reflecting their practice in foreign relations. Notably, some Asian states, including China and Korea, display reluctance to accept the compulsory jurisdiction of international courts or tribunals like the International Court of Justice and International Tribunal for the Law of the Sea. In contrast, there may demonstrations to accept of the dispute settlement system within the World Trade Organization, for example, the WTO, including compulsory jurisdiction of panels and appellate bodies. If indeed a distinct Asian approach exists, it appears to be multifaceted rather than unified in nature. Thank you very much for your attention.